Hi, I'm Tom Dowling, solicitor with Hogan Dowling McNamara Solicitors, and I've been asked to talk about some of the legal considerations arising from COVID-19. We're certainly living in interesting times from a legal point of view. What's happened for me, for us, the kind of inquiries that we've been getting, it started pretty much straight off on Friday the 13th, when certain employers started asking us what is layoff and how do we let go of all our staff. And I suppose the government now are trying to catch up on what was caused by the overnight shutting of creches to start with on Thursday the 12th, and the automatic reaction then by employers to lay off the staff. So I was asked, what is layoff? That was the first inquiry I had. So I had to look it up, and I got the definition, Section 11 of the Redundancy Payments Act 1967. And what layoff is, it's effectively a temporary situation where you can say to your employees, look, I don't have enough work for you at the moment. I expect this to be temporary. I'm going to lay you off for a period, and I expect that you will be coming back as a full-time employee. So the technical definition is where after the commencement of this Act, that's the 1967 Act, an employee's employment ceases by reason of his employers being unable to provide work which the employee was employed to do. And this situation is A, not permanent, and B, the employer provides the necessary notice. The cessation of employment shall be regarded as layoff. So heretofore, I suppose this was something that happened if there was a fire and the premises burnt down, and the employer had to let people go for a short period while they found somewhere else. And it's being used by employers now. I'm aware that some unions have suggested that if it's not provided for in the employee contract, that the employee is entitled to be paid. That's not what the Act says. What the Act says is that the employment relationship ceases for the duration of the layoff period. Now, that said, the service continues for up to 26 weeks. So if your redundancy situation, for example, you need to have 2 years service, or if your service counts for pension purposes, the period of layoff continues to count as service or time in service, even though technically under the Act, the employer-employee relationship has ended. And to my mind, that means that the right to be paid has ended. But of course, some contracts and contracts that I've seen have been very good, and they specifically provide that the employee shall not be paid. But I don't think it's necessary for it even to be in the contract. The form to be used is the RP9, and that effectively contains details of the employer, the employee, and the reason for the layoff. The reason for the layoff is not enough work due to coronavirus or forced closure due to COVID-19 virus. Short time is another option for people. It's very similar to layoff, except that what happens is you serve the same kind of notice, but the employee is expected to, the employer expects that he only has less than half the amount of work available for the employee. So I put you on half time or something less than half time, I pay you appropriately. That might work where employers are trying to stay open and they're trying to rotate staff, so you're only working half a day and you're only working half a day, and we work you at opposite sides of the day to try and keep numbers down, to keep distancing up. The small issue with that is that in order to avail of short time, you're supposed to have a reduced amount of work. I think that will, as it happens, apply, but you just have to be careful that you meet with the requirements of the Act. Both layoff and short time give rise to redundancy entitlements. After, if you've been on layoff or short time for 4 weeks, you're entitled to claim, to apply for the redundancy lump sum, and the RP9 form that you have been served with at the start of the layoff or short time period has the little form for you to fill in as an employee, and the employee fills that in and he serves it on the employer if he chooses to try to get a redundancy payment. So there is some risk with redundancy or situation arising if you lay people off on layoff or short time. If you wish to try to what's called counter the redundancy claim, you have to serve a further notice, which is in the RP9, on the employee within 7 days of receipt of that other notice, saying that as an employer you expect to have continuous work for the employee within a period of 4 weeks of that notice. So you have to have 13-week continuous employment starting within 4 weeks of that counter notice. So that will potentially do away with some redundancy claims, but so layoff is a great tool at the moment, and it can last for quite a while. Some employees, after 4 weeks, if it goes on for 4 weeks, and I presume it will, may claim redundancy, and you effectively have the 4 weeks, the period it takes them to claim redundancy, and then you have another 4 weeks after that for your counter notice denying that claim on the basis that you will have full-time work. So it buys you at least 8 weeks, potentially a lot longer if employees don't serve the notice. The other inquiry I had at the start of this was about sick pay, and I think it was an unusual type of inquiries. They were people who thought that their staff were self-isolating in order to avail of holidays and taking advantage of the situation. I think that has fallen away now at this stage, and most employers are delighted if their staff are staying at home for any reason or any suspicions whatsoever, because the last thing employers that are still open want is to be closed down because an employee comes in with the virus. So I don't think sick pay is an issue at the moment. The other issue then is safe place of work and the obligation of an employer to provide for a safe place of work. And that's covered in Section 8 of the Safety, Health and Welfare at Work Act 2005. It says that every employer shall ensure, so far as reasonably practicable, the safety, health and welfare at work of his or her employees. So that's the obligation to provide and maintain a safe place and system of work. So how do you do that? Well, the tool is in the Act, is in the 2005 Safety Act. The tool to provide that is called, in my view, a risk assessment. A risk assessment is provided for Section 19, and it's used, if you're operating heavy machinery or something like that, your employer should have come along and carried out a risk assessment on that piece of machinery or on that task that you're performing. And he should have analysed, how do I make this piece of machinery safer? How do I make this task as safe as it can be? And that exact same tool should be used in the current environment for employers that are staying open to ensure that their staff are as safe as they can be, because there is an obligation on the employer to provide for their safety and welfare and health. So the next issue then is landlord and tenant issues. That was something that happened with the last recession, where tenants immediately stopped paying rent, and landlords then got into trouble with their banks. I fully expect tenants to start approaching landlords for rent. Well, a number of them will just stop paying rent and they'll close up. But I expect that a number of the good tenants will try to agree rent reductions, and the good landlords will try to agree them with the tenants in turn. That's one thing that led to quite a bit of litigation from my point of view after, not in 2008 or 2011, but after the recovery started, maybe in 2013, these rent reductions that were agreed on the back of an envelope orally in a lot of cases gave rise to litigation. And I would recommend to landlords to put their agreements in writing, to get legal advice on them, so that that situation is avoided. what I would say is you need to be clear in terms of the scope and the duration and the conditions for any rent reduction. So how long is it going to be for? Is it a waiver of the rent, or is it a postponement of the rent? In other words, you pay 50% now and 50% later, or do you just pay 50% now and on that basis, and if it's paid in full and on time, the other 50% is waived? And also, does the other 50% that was waived come back in if you breach your other covenants? So if you fail to pay me rent in the future, I can go after you for all the arrears that I waived as well. And I think that's a good point. I would recommend to landlords actually nail it down, put it in writing, pay for some legal advice, even though it might be difficult to see that outlay at the moment. I think it'll come back to you in the long term. The other thing that I was asked about was insurance policies, business interruption policies. First one I looked at it required damage to the building for there to be a business interruption claim, so it didn't arise. I looked at our own business interruption policy out of interest to see what was covered. We actually seem to be covered to some extent, but there is an exclusion in our one. There's a limit on infectious diseases to 25,000. So if we got an infectious disease and had to close down, we could claim the princely sum of 25,000 for the duration of the closure. But then there's other exclusions. So SARS-1, if you like, is excluded. And so is any variation of bird flu and swine flu. And I don't know whether this is a variation of those or not. I just don't know from a technical point of view. I understand it's considered to be a new disease. So I suspect I'd manage to get 25,000 if we got it. Not a good that'll do me. So yeah, it looks like the insurance companies have the business interruption policies pretty much cut out, but every policy is different. Our one is covered, but very limited amount. So make sure you get some advice on that. And if you are planning on making a claim under an insurance policy, make sure that you keep, if you're paying by installments, make sure you keep paying the installments, because your insurance will be invalidated if you miss an installment. The final thing then that I was going to mention was data protection issues. And I know that some employers have people outside their premises with questionnaires asking suppliers, drivers where they were, what countries they've been in, whether they've been exposed and things like that. I presume, given the level of infection going around the country, that will reduce, because I think everybody is going to have had a risk of exposure at some stage. But the Office of the Data Protection Commissioner has given the okay effectively to those questionnaires. He said it's fine in current circumstances, so you're safe doing that. If you are doing it, make sure you have the little box. You have to have it in writing if you keep those questionnaires. So get the little tick in the box so that you're allowed to keep them. The other thing is, you've seen in the media, the government is saying somebody in the east of the country has it, or somebody in the west of the country has it. They're not giving any details. They're not identifying the people, and that's obviously because the obligation under the Data Protection Act not to disclose another person's data is there, and another person's medical data has an even higher protection threshold. So look, you have an obligation as an employer, on the other hand, to make sure that your staff are safe. So if Johnny in accounting has it, you need to go and talk to Eileen, who sits beside him, and say, look, Johnny has it. You have an obligation to make sure that she knows. She could be caring for an elderly relative. You don't know who she's in contact with, and she needs to make sure that her people are safe. So yes, perhaps not say it's Johnny, you could say somebody you're in close contact with, and that protects him to some extent, but you have to comply with all your obligations, and you've got conflicting obligations, so you have to weigh them in the balance, and you just need to use common sense. Once you use common sense and you have a reason for doing what you're doing, you'll be fine. If you're making an announcement over the tannoy saying Johnny in accounting has the coronavirus, that might be wrong. Just use your common sense and have some regard for people's privacy, but also have regard for your obligations to ensure people's health and welfare and safety, especially at the moment.